In constitutional law of the century 21, the legal interpretation of constitutional principles or fundamental rights entailed great challenge for the legal culture and change in the public administration, in the legislative practice, and even more in the judicial one by the constitutional judge as a defender of fundamental rights in constitutional state of law. Professor Robert Alexi has studied these problems. According to Alexi's constitutional theory, the effectiveness of constitutional and conventional interpretation depend on its rationality. The more rational it is, the more legitimate its practice will be. Consequently, the motives that support judgments about legal principles of fundamental rights, as well as the bounding or balancing of the degree of affectation in a certain case, shouldn't be arbitrary. There must be credible reasons and motives that support this motivation. Because of the rigorous justification of judicial decisions depend on the effective protection of fundamental rights and the legitimation of the judiciary. As well as we can see in some real cases bring up by Legislation 2020 for the purpose of motivation the study of formal logic in legal reasoning. The NASH equilibrium is based on the premises of quantitative assessment, free choice, and fair play rules, which is demonstrated by its application in an appeal of constitutionality presented by the Constitutional Court of Spain related to some articles of Law 21 in 1997 regulations governing emission and retransmission of competition at sporting events. Thus, using an analytical weighted compounding model based on the NASH theory, the collision of fundamental rights caused by the administrative measure that regulates the emission in question is optimized. The collision of fundamental rights under study was made up of the right of property, the reservation of law, the non-retroactivity of the law, equality of normative treatment, freedom of information, and freedom of enterprise. The next following videos, I will be your host. Welcome to the NASH equilibrium in optimizing the constitutional principle of proportionality, a bounded model for collision between fundamental rights. According to Von Wright, the norm defines a normative meaning that provides a specific behavior through an obligation, a permission, or a prohibition. For example, forbidden to park, obligatory silence, or allowed to smoke. Alexis defines the fundamental rights as principles of optimization mandates to the greatest extent factually and legally. For example, the right to freedom, right to choose, right of life, right of education, and the rules as commands that are necessary order for compliance factually and legally. For example, whoever deprives the life of another person will be imposed from 8 to 20 years in jail. For these reasons, rules shouldn't be confused with norms and even less with optimization mandates, since the latter concept implies gradualness in the application of the principles in the context of theory of the decisions. Fundamental rights and close relation between themselves and their respective limits. According to Mexican jurisprudence, when a collision occurs between fundamental principles or rights in a specific case, the interpretant cannot subsume or void fundamental rights. The judge must use a specific method called proportionality test. In this sense, a legal measure may be a law or a legal act of the authority that violates fundamental rights, and the act of authority must be based on a previous law and motivated by a legal fact. Thus, when a certain legal measure causes a collision between fundamental rights, the problem of optimizing, restriction or expansion to the principle of proportionality is the central problem of constitutional law in the 21st century, where the dialectic of legal argumentation and the balance between consent and dissent played a preponderant role. Alexi points out that legal principles of fundamental rights are optimization mandates that have a structural relation with the most important material principle of constitutional law, the principle of proportionality. We can define the principle of proportionality or proportionality law as a legal process, a methodological rule constructed on the basis of logical and rational criteria that give the judicial decision of additional coherence and therefore legitimacy, regardless of the legal category within which we decide to classify it, as a general principle of law or as a structural criteria for the determination of the semantic context and the limit of the fundamental rights. To this effect, Alexi points out that in German constitutional law, interpretation bounding is a part of a broader principle of proportionality, which is divided into three sub-principles: adequacy or suitability, necessity, and proportionality in the narrow sense. The sub-principles of suitability and necessity express the mandate of optimization relative to factual possibilities, while proportionality in the narrow sense studies legal relationships. In this context, according to Alexi, a collision between principles can be modeled rationally by operating with the scales of intensity range. So, we can relate that to decisions in areas where conflicts of interest are intangible legal assets, which that should be protected through a legislative, administrative, or judicial practice based on criteria of the highest rationality and logicity allowed by the legal and scientific culture. On the other hand, like the assumption adopted by Atienza and Rees, they use the term rule and principle as a species of the genius norm to develop their explanation of the difference between easy cases and difficult cases. Here, we will propose this premise in the opposite sense. The principles, due to their universality and formality, are the categorical genre, while the rules and norms are the species due to their specificity, materiality, and derivation characteristics of a superior hierarchical order. Consequently, it can be affirmed that any rule or norm can be deduced from this order, which guarantees the consistency rather than the congruency of the legal system as a whole. We can say that for resolution of particular cases, the principles of fundamental rights are understood as inductive synthesis, which is consistent with their generality. For these reasons, the general principle of law can only be genres, that is, abstract norms indefinite in time, mode, and circumstances. The foregoing in accordance with Cario and Guastini, referenced by Atienza and Rees, who describe various means that adopt the legal principles or general principle of law, whose fundamental characteristics are generality, teleological character, gradualness as their purpose impresses its ends, not bounded, and therefore its application requires interpretative action. In this sense, the Aristotelian notion of genus and species must be understood in relation to the four categorical causalities: formal cause, material cause, efficient cause, and teleological cause. The formal cause is a conceptual representation, the general idea that characterizes something. For example, the idea of a table, the idea of driving, or the idea of obligation. The efficient cause consists of things other than things being changed that interact to be an agency of change. For example, the efficient cause of table is a carpenter. The efficient cause of the money is a central bank. The efficient cause of the law are the source of the law. The material cause is the change or movement determined by the material that makes up the changing things. For a table, it could be the wood or the iron. For a shirt, the fabric. For the fundamental rights, it could be the Universal Declaration of Human Rights or the Constitution. The final cause of change is the good of a thing to be what it is. For the sea, it could be a tree. For a ball, it could be a goal. Or the law could be the justice. In this context, all varieties and difference between principles or fundamental rights, rules, and norms can be explained unambiguously, even programmatic rules. Furthermore, under the Aristotelian scheme, it can be understood that in the logical plane of principle and rights, it is not possible to reach conclusions derived from antecedents or consequence. That is, from the logical group of implications, notions that are valid in the domain of deductive inference within the normative hierarchy where the assumption is valid. Therefore, the process of Alexis and the federal courts that constitute the theoretical framework of this work confirm the nature of the principle as mandates of limitation, whose material application requires reasonableness and proportionality. Therefore, the process of Alexis and the federal courts of Mexico that constitutes the theoretical framework of this work confirm the nature and the principles as mandates of optimization. We affirm that constitutional interpretation cannot be a simple mechanic act of epistemological construction to the literal reading of the text, in order to accommodate a normative content, principle, or to subsume certain facts within a normative content. On the contrary, the constitutional interpretation in relation to a specific case or material situation under appeal has the essential purpose of clarifying the semantic context of the applicable normative statement, as well as delimiting the scope and perhaps collision of principles, values, and related fundamental rights, which implies or displays the given meaning of the normative context. As well as we can see, constitutional interpretation is a highly abstract and complex process by virtue of which the judicial knowledge of the singular experience, the material appeal measure, is interpreted in a more general framework, the concept of law. By this consideration, it is reasoning that in the bounding formula, Alexis incorporates the interpretation of the rights in the abstract sense as essential element of contrasting versus the affectation of the specific measure on such rights. The Aristotelian notion of category also explains the subsumption schema as a logical structure. For example, the difficulty in establishing the likelihood of universal or very general statements led to the definition of propositional function in the context of formal logic. In a relevant way, the semantic theory of proof of Alfred Tarski. Thus, the propositional function, every person is innocent until proven guilty, cannot be classified by its generality as a true or false statement, as long as the subject is not individually identified by a non-logical constant, the name what is proper to him. For example, Jean Valjean is innocent until proven guilty.
The process occurs equivalent in the framework of the Tarskian model theory. In the following terms, one could say that the semantic content relative to the certain fundamental right as a general principle expressed metalinguistically through its logical form transits implicitly from the corresponding constitutional norm up to its articulation in a consistent mode with the logical form to the applicable root of the statements relative to the specific event in litigation. By virtue of the constitutional interpretation according to fundamental rights, this structural mechanism is summarized in the judicial syllogism. It says, then, that the sentence is logical and legal consequence of the premise, that the argument is formally correct, consistent, and materially adequate. For example, all those sentenced are guilty. All thieves are sentenced. Therefore, all thieves are guilty. The above, in addition to lacking legal sense, a judgment on a collective is illegal in a democratic state.
The concept of a structure referred to above corresponds to a model of, say, normative hierarchy. Under such intellectual discipline, it is understandable that the logic in the process of substantial represents the department of legal argumentation, more objective, integrative, and general than the generic and eclectic concept of reasonableness. Only thus the legal truth, formally correct, and materially adequate, has more force of conviction, justificatory efficacy, and credibility than the valid laxity of the reasonable or the so-called guarantees.